Brown was a sole practitioner solicitor, but also carried on a range of other activities, mostly in the finance sector. As a result of these activities, it was not unusual for him to be holding large amounts of client money on trust. When a client had large amounts of money on trust and when they wouldn't need that money in a hurry, Brown would invest that money in a term deposit and credit the interest back to the client so that the client's money was making some more money, and that was perfectly proper. However, if the clients did not have a large amount, sometimes Brown would aggregate together the money of different clients and invest that. When that money matured, Brown kept the interest for himself as part of the firm's profits. No client ever lost a penny as a result of this activity. However, the difficulty was that he didn't have their consent to invest their money and keep the proceeds. And there's an old rule of equity that a fiduciary, a person in a special position of trust, cannot profit from that position of trust. It was all going along quite well until, amazingly, Brown tried to claim a form of income tax relief associated with those profits. The Inland Revenue Commission, which is the tax office in the UK, refused, and it ended up in court. Lord Reed wrote the leading judgment, but my favourite expression of the principle comes from the judgment of Lord Upjohn, who said, "One of the most settled principles of the law is that a person who is in a fiduciary relationship to another may not make profit out of his trust. A professional advisor, whether he be solicitor, factor, stockbroker, or surveyor, is of course in a fiduciary relationship to his client, and when he is entrusted with his client's money, he can make no profit out of it. He may make proper charges to his clients for the professional services he renders to them, including, no doubt, the investment of their money, but he cannot, without his client's agreement, make indirect charges by way of retaining interest on the investment of his client's money. From this case, we learn that trust money should only be allowed to earn interest if we can clearly tell which client owns the money, because the interest belongs to them too."